Okay, everybody, Stephen Key here, and I have a very special guest. We have a patent attorney, is that right?
Trademark attorney.
Trademark attorney, that's right. There's a difference?
Oh, yes. Yes.
Oh, good.
Well, you focus on patents and licensing and all that good stuff for helping inventors. So as you probably know, patents protect ideas that are new, unique, and non-obvious. Trademarks, on the other hand, will protect usually a brand name or company name. So it's generally any word or design associated with a particular product or service. But you can also get trademarks on weird things like the smell of Play-Doh, sounds like the NBC.
Wait. Before we go into that, let's back up for just a minute.
Sure.
First of all, please, Tamara, thank you for coming on.
Yeah, my pleasure. Thanks for having me.
Yeah,
I get excited when we talk about trademarks.
I'm really glad that you do, because I get excited too about intellectual property and ownership of your creativity. But before we get started, could you talk a little bit about who you are, what you do, a little bit?
Yeah, so I consider myself a trademark attorney. I've been practicing since 1998, as you can tell from the gray hair. Focusing mostly on trademarks. I worked at a big firm right out of law school where I got trained on basically how to protect a brand. Then I worked as in-house counsel for a few big companies. And then I started my own practice about, I think 17 years ago now. Okay. So over the last 17 years, I've helped a lot of companies register their trademarks, enforce their trademarks against other parties, draft licensing agreements, do procedures before the Trademark Trial and Appeal Board. We try to cancel or oppose someone's trademark. Trademarks probably take about 80% of my working time. We also do some business contracts, some advertising disputes. There's regulations about, which maybe we can talk on a different session about that, but regulations about what you can say about your product. Okay. So that's about the other 25% of my practice.
Okay, so let's also talk about, you had to pass the bar, correct?
Yes.
Okay. So why did you go into, and a lot of people don't understand this, and either do I. I asked you, are you a patent attorney? And you said, no, I'm a trademark attorney. So why did you specialize in that area and not the other areas?
Well, honestly, I kind of fell into it. I originally went to law school because I thought I wanted to do environmental law. And then during first year, I took an elective for environmental law, and it just seemed really boring. I don't know if it was the professor, the material. There were a lot of acronyms you had to learn. He made it seem like it was an old boys club. So it kind of quashed my hopes to be, defending the environment. And then the next year I took intellectual property, and it was like a light bulb went off. It was like, oh, choir sings. I'm a geek. We actually have an application pending for we're the geeks that lose sleep protecting your brand. I used to write computer programs in the basement when I was in like 4th grade. So when I took IP law, I realized like, oh, here's this area of law where my geekiness can actually come in handy, because I understand, a little bit of software technology stuff that people are talking about. And I happened to get, the highest grade in the class, not to brag or anything. And then I got an offer from a large firm because, I graduated high up in my law school class, and never looked back.
Okay, let's talk about trademarks.
Sure.
Okay. What is a trademark? Start there.
So the definition of a trademark is the word or design that is used to protect particular goods or services. But as I mentioned, trademarks also can protect other things like smells, design, colors, sometimes sounds. So like the smell of Play-Doh, the color brown for UPS, Tiffany blue, the little sound when you open up your Netflix, things like that. So you can get trademarks on a lot of things if you're creative.
That's amazing. I didn't know that you could get a trademark on a smell. How about a Harley Davidson, that certain sound they have? Is that a trademark on that?
That's a good question. I don't know. I wonder.
It's a very distinct sound. I know
it is, yeah. Yeah, I wonder.
So when you file for, I'm very familiar with filing a trademark on a name, but how would you file a smell?
So usually, the Patent and Trademark Office is almost 100% virtual these days. You file almost everything online. For a smell, I believe you do need to submit a physical specimen. For Play-Doh, I think they had to
Okay.
provide a hunk of Play-Doh and send it to a certain office within the USPTO for them to smell it themselves.
That's amazing.
Mhm.
Okay, so what are the benefits of a trademark? Why do I need one?
Well, you don't necessarily need one, but getting one does give you a lot of additional rights. So, people think, oh, I got my patent, I'm selling my product, I really need to rush and get my trademark. It's sort of a myth, but sort of true. So you do have what we call common law rights in your trademark beginning on the date of first use. So if you start selling a product under a unique name, you do have rights based on wherever you're selling that. However, having a formal trademark registration has a lot of benefits. First of all, it gives you the presumptive nationwide right to use that mark in connection with the goods or services subject of your application or registration. It's an asset of the business. So if you ever sell the business, it goes along with the business. It adds a lot of value, sometimes millions or even hundreds of millions of dollars. It can be licensed. I know you're really into licensing. So it is a valuable asset for licensing. And it will not necessarily prevent other people from using a mark, but if they have an attorney and they're searching to see the availability of another name, your trademark details will come up on their search reports. So they'll be on at least constructive notice that someone else has already claimed rights to that mark, and hopefully they'll choose something different.
So when you file for a trademark, a registered trademark, how long does it last?
It can last forever as long as you're filing the appropriate renewals. So you need to file a renewal once you get a registration. It's good for 6 years. You do need to file the first renewal documents between the fifth and sixth year. And then you need to file again between the ninth and 10th year. And then you need to file every 10 years after that. So if you keep up with your registrations, don't lose the ball, then you can have it last forever. I have had situations where it used to be they would send physical postcards to remind you of renewal dates. I had one situation where another law firm engaged me. They had an attorney who was handling trademarks, one attorney at the firm. That attorney left the firm. They were in downtown Denver at the time. So the attorney left the firm. The firm moved offices from downtown to Cherry Creek. And they they didn't have anyone else doing trademarks. So the client's renewal documents were sent to the physical office to the attention of the prior attorney at their prior office. It never made their way to the new office. They really had no idea about it. And then the client was about to sell their business and they were doing due diligence, realized, oh shoot, our registration has expired. What do we do now? So there was like this mad scramble, and it turned out someone else had applied for a very similar mark in the meantime. Yeah. So we had to work out this deal where ultimately I think that we got the other party to we had them stop using it, but then they paid us some fee to cover our attorney's fees because technically the new party was infringing. My client was still using that mark continuously. They just forgot to do the renewal.
Well, tell me about the classifications a little bit, because I know back in the day, Monster Cable, I think it was Monster Cable, really was defending that their trademark. But anybody that used the word monster, they were kind of going after everybody. So talk about classifications.
Yeah, it's funny you mentioned Monster. We had a matter once against Monster energy drinks. Probably shouldn't mention them by name, but I had a client that was making that sells like pallets of empty containers, and they weren't even using the word monster, but they had like a claw mark
Yes.
as part of their logo, which is part of one of that other company's logos. They filed an opposition. They just didn't give up, even though and no one's accidentally going to buy 1,000 empty containers for perfume when they're intending to buy an energy drink. But eventually the client ran out of funds and we chose a new mark. But anyway, getting back to your question about classifications. I believe there are 45 different classifications in the trademark system. So everything from like medical services to apparel. It's one of my favorite ones, candles, fragrance. I do a lot of those, consumer products. Class 35, which is like a lot of business services. I don't know all the classes
Okay.
by heart. The USPTO does have a searchable identification of goods and services manual. So if you're ever unsure, you can check the manual to see what class your goods and services fall into.
So let's talk about that for a minute so everybody can understand. Let's say I have a trademark that I want to use on t-shirts.
Mhm.
And maybe just t-shirts apparel.
Mhm.
So I would file that trademark and that classification that covers apparel.
Mhm. Yeah, well, you bring up a good point about t-shirts. But first, let me go back to the monster thing for a second
Okay.
and classification. So trademark infringement is based on whether a reasonable consumer would be confused seeing the two goods
All right.
or services next to each other. Based on, and usually don't apply in all 45 classes, although there have been some companies
Oh,
that just try
gee,
to like take a word out of
really?
circulation. Yeah. So generally, if you have like cable services or energy drinks on the one hand and empty pallets of containers on the other hand, the USPTO probably wouldn't reject that application, but someone, if they have a really aggressive attorney like that other company does, they might send you a cease and desist letter, but I think it would be defensible. But anyway, you should keep in mind that trademark confusion isn't just like, are you using the same name or design? It's actually based on a bunch of different factors under a famous case, the DuPont case. There's 13 factors. It's like, how similar is the mark? What are your channels of marketing? How sophisticated are the consumers? What's the price of the goods? Usually someone's not going to be confused if they're spending $100,000 on a new Mercedes versus $1 on an energy drink. But I'm sorry, I'm trying to focus on all your
Well,
questions. I just have so much to say.
what's really crazy about it, I didn't know that because filing in different classifications, it does cost money every time you file a different
Yes. Mhm.
classification. But companies actually filing all of them?
So it's usually these foreign companies that are just trying to secure rights in a word, and then they'll send these they're like trolls, we call them. I think you have patent trolls too. So there's trademark trolls. The USPTO has started cracking down on them. But yeah, it happens. Or you'll see like maybe they just file in one classification, but like in class 25, it'll be like t-shirts, sweatshirts, headbands, hats, actually sunglasses are a different class, socks, shoes, leggings, leg warmers, they just have like any potential
Well,
thing that someone could ever wear. They're listing it in their application, which
well,
is, by
I
the way,
want
not the best strategy because applications and registration, well, applications get examined. Registrations actually have been audited recently. So if the USPTO sees a registration like that, where it's just like 100 different things, when it's time to file your renewal documents, you need to show continuous use.
yeah.
And often, if you're only submitting pictures of one or two things out of that list of 100, they'll come back and say, well, we need you to send these 98 other pictures or else remove them from your application or your registration, because you really do need to have continuous use in order to maintain your
So
mark.
they're getting caught. Okay, good. I'm glad to know
Yeah.
because it sounds a little ridiculous. Some
Yeah, it's
people,
pretty shady.
yeah, it does. Um, I was in the guitar pick business making guitar picks. And I was building clamshells to carry my guitar picks in the
Mm.
clamshells. And there was one particular company I really liked. It was called Coffin Case. They made
Mhm.
uh, guitar cases that looked like coffins. They were
That's cute.
great. And I
Mhm.
thought, well, gee, wouldn't it be really great to do a little clamshell in
Mhm.
the shape of a coffin,
Mhm.
right? And put
Mhm.
my skull guitar picks in there. How
Mhm.
great is that? What a great little tie-in, right? Well, I got a cease and desist letter,
Mhm.
coffin case.
Mhm.
And I guess they had filed the trademark, not only the word coffin case, but the shape of it, right? So
Mhm.
talk about those images because they filed the name and the shape, and they were
Mhm.
able to say, "Hey, Steve, your shape of that clamshell,
Mhm.
we think it's infringing on our trademark."
Yeah, so usually the first trademark you'll file is for a plain word, which gives you protection to use that in any font or color or stylization. And the second one is the logo or design.
Yes.
So and then you can also do trade dress registrations, which
Okay.
is like if you have, I would have to look at it, but I wonder if they had also a trade dress registration on the shape or if it was just the logo.
Just the logo. The
Oh,
logo,
the
they had the
logo.
name,
Uh-huh.
and the logo was around the name.
Uh-huh. I
Very,
see.
very clever.
Yeah, I mean, in that case, they probably had an argument about zone of expansion, guitar cases and guitar picks kind of used by the same audience, probably sold in
Yep.
the same retail channels.
Well, I think the point is they had an argument to make.
Yeah,
And no
yeah.
matter if it was right or wrong, we of course worked it out with them. But I thought it was really clever the way they used the name and the shape within the same
Hmm.
trademark. So I
So did
file a
you stop
trade.
using it?
What's that?
Did you stop using it?
Yes, I did. Well, we're in the same industry and we all want to be
Mhm.
friends. So it made no
Yeah.
sense, right? So, but here's the question I have. So you file on, I can file on the name. There's a certain fee with that, but I
Mhm.
also have to do another filing on the logo or the look of that. Is that another?
Yeah, you can do a composite mark where you're protecting like the stylized version of the name
Okay.
with the logo.
Okay.
But I do recommend doing the word by itself and the logo. And yeah, they're separate. So the filing fee right now is $250 if you're using the Tease Plus, which is for like canned descriptions,
Okay.
or $350 if you're doing a custom description of goods and services.
Nice. So help everybody understand that some names just won't be able to be trademarked. Okay.
Yep.
So can you
So
explain that
there's
a little bit? Because sometimes I come up with a really clever name,
mhm,
but it's maybe too descriptive,
mhm,
like easy open,
mhm.
you know, can I, what's the difficulty when I do names like that are just so easy, descriptive?
Yeah, it's always easier to register something where it's weird and unique than something that describes the goods or services. Usually the Patent and Trademark Office will reject marks where they are merely descriptive of the goods and services. So if it's like black frame or brown desk or something like that, you'll get a rejection. But you can use real words, like Apple for computers. Like that's a unique combination, right?
Yeah,
Who
help
would
me
think?
understand that. How, is it because they used
Yeah.
Apple, but it wasn't really food related, but it was related to something else? Is that the reason why they were able to get that?
Yeah, exactly. Yeah, you're using a real word, but not for what people usually think of it for. So you're not registering Apple for fruit, right? Well, that would get rejected. But like BlackBerry for those little handheld devices. But
Okay.
again, the strongest marks are like Lululemon or Starbucks or Kajabi or something else where it just doesn't even mean anything in the dictionary.
So let's say I file in the United States, but I want to file around the
Mhm.
world. How do I do
Mhm.
that?
So there's a couple ways to do it. If you file within the first 6 months after your US application, there is a window, that window of time through what's called the Madrid Protocol. You can actually use the USPTO system to file internationally in countries. There's about, I think, 3 dozen countries that are part of the Madrid Protocol. So you can use the USPTO system to get the benefit of your US application date in foreign countries. Otherwise, you need to engage local counsel. And sometimes it's easier to engage local counsel even if you are within that time frame. It really just depends on the country and the circumstances.
So do people do that typically if they're going to sell international?
Um,
They
it
probably do.
depends. I do represent some companies that file internationally. Most of my clients are only selling in the US. Or I have a couple clients where they started in another country and then they want to get rights in the US as well. And by the way, it's not automatic. The USPTO will still examine even a foreign application where they have prior use in a foreign country. They'll still look and search and see if there's anything already pending in the United States, and they'll reject it if there is.
Okay, what about I'm selling on Amazon,
Mhm.
and boy, they took my images, but they took my name too. I mean, they just take everything because I'm doing so well.
Happens all
But
the time.
yeah, so how powerful is a trademark to tell Amazon, hey, they're infringing here? Is that a pretty powerful tool?
Yeah, in fact, I think it's really the only way. I don't know, you probably do more on Amazon than I do, but I haven't had luck with clients that don't yet have a trademark registration, getting Amazon to take down the infringing sites. If you have a trademark registration, it's pretty easy. You know, they have their online system where you can just submit your registration details and the infringing page, and they'll take it down. But otherwise, if you haven't filed anything yet, it's a little difficult. And then you probably need to send them a cease and desist and find other ways around it.
Okay. Now here's something that's of interest, I think, to all of us. A lot of celebrities, maybe they say something and it goes viral, or they do something and they rush to file trademarks on it all the time. And you're going to show the audience, you're going to do a little video for us to show how to file a trademark on certain names. Are you going to you're going to record
We can
that
do it
and
now,
send that to
actually.
us? What's that?
We can do it while
Can you
we're
share
online
this?
if you would
Can you
like.
share a screen and do that now?
Yeah, let me
Oh,
see.
great. Yeah. What about Taylor Swift? What is she filing? Can we
Well,
find
let's
her
see.
somewhere?
So here we are on the USPTO website, and my favorite page, the trademark page. And then they have this easy tool to search the database. So you have a couple ways of searching. If you already knew what word you were looking for, you would do a general search. We are going to search by owner. We're gonna put in her name, although I'm guessing she probably has like some entity that holds all her IP.
Oh boy.
Oh wow. Looks like she did file a bunch as an individual. I wonder why they are all
Holy cow.
dead or abandoned. Let's look for live only.
So we can see what she's abandoned. Maybe she thought was a good idea, but she walked away from it. We can see that as well.
Here it is, TAS, right? Yeah. So the options here, you can see what's live, what's registered, already achieved registration.
Look how many dead ones
Which
there
looks
are.
like 66 are registered. There are none pending under her name, and yeah, there's 47 dead ones. So now we see, I saw on one of them, it was like TAS management. So let's see what shows up under that. Oh yeah, 302. Oh my gosh, I'd love to be her trademark attorney.
Wow.
So let's look at the new ones. So it looks like she is trying to do the names of her songs, Swift Miss, her initials.
I mean, the word, look at these words though.
And look at all these classes that she filed in for Lover. So it's a stylized design, and then she's covering like everything. Patches, online retail store services, entertainment, keychains, stationary pillows, mobile phone cases, artwork, nylon straps, and yeah, like I said, each classification is an additional either 250. These are all, I think, in the lower 250 fee, so it's either 250 or 350.
So wow, she's pretty active.
Very active, yeah.
And let's say I watch her do something and I trademark something that's she's doing, and if I beat her to the trademark office, do I own it or can she challenge it?
Oh, I'd love to talk about that. Let me stop sharing for a second. So yeah, that's actually a myth where people think, well, you know, I heard this really cool phrase and that, you know, John Elway said, or Taylor Swift or Travis Kelce or whoever. And it's not trademarked yet. So if I trademark it, if I register it with the US Trademark Office, then I can stop them from using it. I can make a lot of money, right?
Yes.
And I'm like, no, it doesn't work that way.
Why not?
No, because the US Patent Trademark Office actually requires you to have use of the word or design with those goods or services that you're trying to use. And remember, we talked about common law rights. So if someone else, first of all, they may or may not even care, like that, what was that? Taco Tuesdays, like he really cared about that. But you know, someone maybe has a cute phrase and they don't care if you make a whole line of apparel around it or not.
But
But
wait a
if they
minute,
do
but
care, yes, go ahead.
But what, okay, let's say I'm watching something, I see something, I go,
Mhm.
look, I'm gonna trademark that.
Mhm.
And I apply for a trademark, but before I
Mhm.
apply for a trademark, I put it on like cups and t-shirts, and I
Mhm.
sell it on
Mhm.
Etsy or whatever, and then I file for
Mhm.
my trademark. Can I still get ownership of that over that person?
Uh, now that's a really good question. So you heard them say it, you went ahead and applied for,
Yeah,
or you didn't apply yet, but you started already selling
yeah,
merchandise
because
under it. You're probably gonna get a cease and desist if it's like a celebrity or someone with a lot of funds to spend on legal.
yeah, but I thought
Um,
it was first race to the trademark office.
Well, it's also first use, though. Remember, you have common law rights when you first start
Oh,
using a word
oh,
in connection with goods and services.
I
And now
see.
you're
Okay.
getting into kind of a gray area. So they used it, they just like uttered the phrase, but
Yes,
they didn't necessarily start selling the merch. And now you want to start selling the merch and
yes.
get a trademark on it. You might be able to, you could technically,
Okay.
but yeah, depending on who said it, you may or may not get a cease and desist letter.
So it's really who does it first. So for instance, if they have a lyrics, they probably copyright all their music, and I couldn't take any lyrics from it, not even one
Right.
line.
Probably not. Yeah, there is the fair use argument where it's like
There's a
if
lot of
it's
gray
such a
area.
minimal amount,
Okay, well, you
but
really busted my bubble here. I thought I was
I'm
going to
sorry.
jump on all these celebrities
Yeah,
faster than they
no,
are.
sorry to
Okay.
burst your bubble.
Okay, what about Travis Kelsey? Can we look at him for a minute because he's
Sure. Yeah, let's
becoming
look at
really
Taylor's boyfriend.
popular
Soon to be fiance, I heard.
soon.
According to the magazine I read. Oops. Where did we go? There we
I'm
are.
sure he's filing crazy too.
You think so?
Yes.
Let's see. Hmm. But then I wonder also if he has let's look under his a general search. See, he also has an entity, TMKA. Oh,
How
there's a
did you
couple
find that?
things.
How
Actually,
did
we
you?
don't know. So this one, I just did a general search for his name. So there's a couple entities. There's TMK Enterprises, which looks like it's in a bunch of different classifications. There's this New Heights Holding Company, Kels Food Group,
Kelsey
Russell
Jam.
Travis. That's interesting. Kels
So
Jam. I don't know which one is actually associated with him.
look at wines.
Hmm.
So really, I could almost look at what type of business they're going to probably go into by looking at some of the trademarks.
You could, yeah. Actually, trademarks can be a really good tool, and not a very, let me stop the share, not a very widely recognized tool, but some venture capitalists will look at trademarks to
Oh,
see like what's trending. There is some way to file like a secret trademark application in Jamaica. I went to a webinar about once, where Apple actually uses that, and then they get foreign priority, and then they file in the US based on their foreign rights. So, but you can use the USPTO searching system to get not inside information, but not generally well-known information about companies.
but I can see the future.
Kind of, maybe, yeah. Yeah, because remember also, I don't know if we talked about this, but the trademark process takes about a year between when you file your application and when it ultimately gets registered. So yeah, if someone's filing an application, you can tell what they're going to be selling or providing in about a year, or maybe they already started doing it and they're filing based on their current use.
Interesting.
Mhm.
Wow, this has really been fascinating. I want to have you back.
For me too. I would love to. I love talking about trademarks. I could literally talk about it and have talked about it for hours. I did a CLE once for other attorneys that was like 4 hours nonstop. I think I got a few beverage breaks, but yeah,
I'm so
that was
embarrassed to
intense.
say that my company, InventRight, we've been in business for 25 years, and I never filed for a trademark until
Oh, what?
25 years.
Why?
And
That's crazy.
I finally filed in 2019, I think.
Okay. Did you get it?
Oh yeah, of course.
Okay, good. Okay.
But I didn't really think too much about it, and I thought, but I finally filed, yeah.
That's
After
so interesting because I would think you're always thinking about trademark patents and intellectual
I,
property. What happened? You never thought about a trademark
I
before?
just, we do such a unique thing that I
Mhm.
didn't think anybody would care to even bother jumping in our field. It was because there's not a
Hmm.
lot of people doing education, so in inventing
Hmm.
education. So
Have you had any infringers trying to use your
no,
name? Oh,
no.
that's great. You're lucky.
Well, yeah, I think they do copy some of our material sometimes, so we see that occasionally, and it's I don't know.
Yeah,
Thank you so
imitation is the highest form of flattery, right?
I you like to tell yourself that, I think, at times to feel better about it, but
Mm.
fascinating. I'm gonna have you back tomorrow. Thank you
Great.
so much for coming on.
Yeah, my pleasure. Thank you for having me.
You guys, one last thing I want to say. She's going to put information down below. If you need some help with your future business and you think a trademark is really important, which I think it is, check out down below. Her information will be there. And if you need some help, she's there to help you become more successful because you need to protect whatever you're doing. So Stephen Key here,
Yes.
InventRight TV. Thank you for watching. Subscribe down below and give me a thumbs up. Thank you so much.
Thanks, Stephen.
If you're not sure about this and you need a little help, please give us a call. We have a program called Gateway where we do everything for you. We know how to reach out to the right companies. We know how to reach out to the right people. We know how to make sure your marketing material is communicating correctly so they can look at it, they can make good decisions. We know what questions they're going to ask, and we can be prepared for those questions in advance. And when that licensing agreement comes over, we can help make sure it's a fair and balanced licensing agreement so everybody's happy. Basically, we're doing all the work for you. It's our program called Gateway, and if you need help on any of this, please pick up the phone, call us, and let's see if Gateway is right for you.